Um, I really just wanted to thank everyone for coming. I hope that you learned something or were somewhat entertained, and not only by Thibault and his last panel, but I think these are some very interesting questions, and I don't see Fred Jenny here, but he made the point a week or two ago that that concern for big tech is passé now. What all the antitrust enforcers are concerned about is sustainability, and assuming he knows what he's talking about, and I think we can assume that. This is not going away. We'll have lots more to talk about with respect to these topics, and we're delighted that you decided to spend your day with us talking about these topics. So thank you very much for coming. Thanks to the university for hosting us, to Antonio. Thank you so much for having us. Thanks to the ICLE and UC3 staff for helping get everything ready to go and making it all work. And now I want to invite Santiago Martinez Lage to say a few words. Santiago is, well, I think one of the most prominent lawyers in Spain, one of the great experts in European law and antitrust law, and also for how many years a superstar arbitrator. Now president of the Ayala de la Torre Abogados. As of just a month or so ago, right? And we're delighted that you agreed to give your thoughts on what we've talked about, and take it away, please.
Thank you very much, Geoffrey, for these kind words. I have to confess that today I feel as an old-fashioned scholar or practitioner. Because when I started studying these matters in the early 80s of the last century, the only goal of competition law was market efficiency. And as a consequence of that, consumer protection. It is true that concerning the European Community competition law, it was also mentioned market integration. That was also mentioned during your debate, and which for me has always been rather problematic. For instance, the use that the European Commission made of competition rules in the field of pharmaceutical products concerning parallel trade when there is no harmonization of prices. I close brackets, Marcos. But nothing was said at that time about democracy, sustainability, industrial policy, or broader social goals. This is why I am very happy to address you these closing remarks instead of the opening speech. Because when Lazar contacted me to invite me to pronounce these words, I had to confess that I didn't have a clue about the matter. So I said, I'm ready for closing remarks because I hope to learn what is going on. Well, I have discovered today, and I have to confess that I have also read the papers you recommended, some papers that Borja, sitting here, sent me, and some papers that I prepared a little before, obviously. But I have to confess that these new things, that what I have learned today, in fact, didn't exist in the 80s, but not even when I stopped practicing competition law. That was only 5 years ago. 5 years ago, in Europe, in Spain, these were not questions to be discussed. I learned a lot. Let me start by saying that I have been very impressed by the first presentation of Pilar Canedo. That was a very good summary of the state of question for an ignorant as I was when I started. And thank you. And I was impressed by this sentence in her presentation, that the antitrust authorities need to adapt the criteria on which decisions are taken according to other goals. For me, this is the most important message. Antitrust authorities have to adapt. Adapt, I think it's a good verb to express what we need. Adapt, adapt. Personally, my personal perception is that sustainability goal is the most mature one, as Maurice Dolman's presentation of the decision tree for making, it shows that the application of paragraph 3 of Article 101 is mature to be applied to this subject. For me, it seems to be the more mature. But I have also to confess that I discovered that I had only had a certain intuition that in competition, antitrust and democracy had a strong connection. Filippo mentioned today not only Daniel Crane article on how the rise of Nazism in Germany found a good field because the economy was concentrated and cartelized. And he made also a reference to an article that I haven't read, which was antitrust enforcement in Spain during Franco's regime. I'm going to comment 2 or 3 things that maybe you don't know, which are very illustrative of what we have discussed today. Most of you remember or know that in 1953, the United States of America and Spain signed a mutual defense help a treaty during Eisenhower's mandate and Franco's endless regime. What is not so much known is that a secret condition for the signature of this treaty that put an end to the isolation of Franco's regime was that Spain should adopt an antitrust act following the model of the Sherman Act. And so it did. Only 10 years later, in 1963, but it was formally very similar to articles at the time, 81, 82, provision of horizontal and vertical agreements and provision of abuse of a dominant position. But this act was hardly applied because there was no political will to do so. In fact, some of you don't know it, but when the first test of this 1963 act didn't grant the authority, the administrative authority, the power to impose fines. They only were allowed to propose fines that were to be imposed by the government, and they were not. This is why it was, there was a professor, Professor Garrigues, known certainly by all the Spanish presidents, who qualified this act in Spanish as an exabrupto jurídico. My friend Lazar facilitate me a very good translation. A legal aberration, ex abrupto, a legal aberration. Why? Because the economy, Spanish economy, Spain at that time was not only a political autarky, it was also an economic autarky. It was completely capitalized. So it was impossible to impose. Some of you will remember that at that time, there was a figure called vertical trade unions. Vertical trade unions were trade unions officialized and divided into workers and the economic branch of the trade union. Well, the economic branch of the trade union, by sectors, by industries, was supposed to be for two goals: negotiate reduction of tariffs of their inputs imported, and negotiate the best tax treatment. But in fact, they were the house of cartels. I mean, the main topic was to say, to partition markets and to have, so it was impossible. So it is not to go beyond that. I will finish by thanking, first of all, ICLE and the Universidad Carlos III, you, Geoffrey, Lazar, Antonio, and congratulating you for the great success of this conference. Indeed. Secondly, of course, I would thank and congratulate the extraordinary lineup of scholars and practitioners that have been present with a degree of excellence difficult to find in this kind of events. Thirdly, I want to thank all of you for attending this event and for your contribution to the debate with your questions. I have appreciated particularly Marcos Araujo, one concerning this approach of the European Commission to the need to have losses to obtain certain benefits. And finally, I want to thank, and I will change into Spanish because I want to thank los técnicos del sonido que nos han permitido disfrutar de una impecable audición, particularmente a mí, que como veréis tengo un implante coclear y necesito algunos hearing aids. Muchas gracias a todos y enhorabuena por la organización. Muchas gracias.